If you get sick and need a day off, you generally expect to return to your job in the next day or two. But what if the sickness or family situation will keep you off the job for weeks or even months? Before 1993, employers could handle leaves however they chose. Beginning in 1993, the Family and Medical Leave Act, or FMLA, set a minimum standard for leaves at the federal level. Depending on your company's size, you may be eligible for an FMLA leave under federal law. Instead or also, you may be entitled to a leave under state law or the terms of an employer policy or employment contract. Here are some general guidelines. Both public and private employers are subject to FMLA leave requirements if they have more than 50 employees. If you work for an employer subject to FMLA requirements, you're eligible for an FMLA leave if you work for your employer for at least a year, you work at least 1,250 hours a year, and you're employed within 75 miles of the workplace. FMLA applies equally to men and women. Under federal law, FMLA leave is unpaid. However, if you have paid time, it may be used for part or all of your leave time. If so, it will be used first and applied toward your total time limit for leave. For example, if you have a week of paid vacation and 12 weeks of unpaid FMLA leave, you may receive 1 week of paid leave and 11 weeks of unpaid leave. This is called substitution of paid leave. You can request up to 12 weeks of unpaid leave within a 12-month period for a variety of reasons, such as caring for your newborn child, caring for your seriously ill child, spouse, or parent, and for the care of yourself during a serious illness that makes you unable to perform your essential job functions. A 2010 change to FMLA expanded military caregiver leave, also called covered service member leave. Your leave can be longer, up to 26 weeks, if it includes care for a spouse, child, parent, or next of kin who is a covered service member who has a serious injury or illness and who incurred the injury or illness in the line of duty and while on active duty. If you and your spouse have the same employer, your total combined leave to care for a new child or sick parent may be limited to 12 weeks. 24 weeks in the case of care for an eligible military person. FMLA leave can be intermittent. For example, you could take part of the 12 weeks off when a parent is receiving cancer treatment, return to work when the cancer is in remission, and take time off again for another round of treatments. If you know about your leave in advance, provide at least 30 days notice to your employer. If not, be sure to follow your employer's policies for notifying work. Your employer may require you to certify the need for medical leave, so check your employer's requirements carefully. Given privacy concerns under the Health Insurance Portability and Accountability Act, HIPAA, the employer's contact with the healthcare provider will not be your supervisor, but can be a human resources professional, leave administrator, or management official. Employers may only ask about information required by the Federal Leave Request Form, which does not require a diagnosis for certification. During an FMLA leave, your employer must continue your health insurance coverage at the same level and under the same conditions as your previous coverage. The employer may require you to pay your share of premiums, and your employer is not required to continue benefits other than group health during your leave. When you return to work from an FMLA leave, you may need to certify your fitness for duty to return to work and perform the essential functions of your job. After a leave, your employer must restore your original job or find you an equivalent one. You cannot be required to recertify for benefits. Employers subject to FMLA put up a poster in the workplace and provide additional information to employees. Carefully read the information about your federal FMLA rights as well as state and employer leaves to get the support and information you need.